You have a right to healthy and safe housing. This is called habitability. The right to habitability is the right to have housing that is fit to live in. Landlords and tenants have obligations when it comes to a safe and healthy living space. In this video, we will explain what those obligations are, and we will also explain your rights as a tenant. Under California law, a landlord is required to provide housing that meets building codes and minimum standards of health and safety. Some examples of the basic things a landlord must provide to keep you safe and your space livable are secured windows and doors, hot water and plumbing free from leaks, adequate heat, working electrical outlets, a clean living space with no garbage or vermin, and floors without tripping hazards and maintained stairways. If the conditions of your housing are not safe or livable, what do you need to do?
You are required to tell your landlord about the problem. What is also critical is that you document everything.
Submit your complaint to your landlord in writing and keep a copy. Save text messages, emails, and letters. If you talk to your landlord about the problem, follow up by text or email to summarize what you talked about. And again, gather your evidence, take photos, keep a log of recorded temperatures if your heating doesn't work, take a video of the water spilling out of an overflowing toilet or a leak under the sink.
Once the tenant gives notice to the landlord of the problem, the landlord should respond in a reasonable time. What does reasonable mean? It depends on the problem. For example, if it's an issue that threatens your health and safety, your landlord should respond in a day or two. If your toilet isn't working, that's an emergency. You can't live in a unit that doesn't have a working toilet. If it's the middle of winter and your heat goes out, or your front door doesn't lock, those are emergencies. However, if you have a leaky faucet, this might not be an emergency. There's no set time to respond, but again, your landlord should fix the problem within a reasonable amount of time.
But what do you do if your landlord doesn't make repairs? Here are 5 options of what you can do. Number 1, pay rent under protest. This means writing a note in the memo line of your check or money order. For example, rent for July 2022 paid under protest. Keep a copy of your check. By paying, you do not lose your rights to have the issue fixed. Number 2, report to city and/or county code enforcement. Number 3, report to county vector control for issues with rodents, birds, insects, and other pests. Number 4, sue in small claims court. And 5, file a local rent board petition. We have sample letters and additional information about these steps on our website.
There are 2 options we don't recommend without first speaking with a lawyer. 1, repair something yourself and deduct the cost from the rent. Or 2, stop paying rent entirely. These options are risky and complicated, and your landlord could file an eviction against you for not paying rent.
What if my landlord retaliates when I complain?
Retaliation is illegal, but unfortunately, it can happen. It could look like raising the rent, filing for eviction, shutting off the utilities, or changing the locks. Reach out to us if any of these things happen for advice about what to do.
Finally, we want to highlight your responsibilities as a tenant. You must keep the unit clean and sanitary, throw away trash, properly use plumbing and electrical fixtures, not damage the unit, and use the space as intended. Whatever challenges you are facing, know your rights and get help. Call our legal advice line at 1-800-551-5554, and please use the resources on our website to find more information. We are here to help.